All right. Hi, everybody. My name is Gregory Cagle,
And I'm Adam Pugh.
and we want to welcome you to our webinar on financial stewardship and what we've been calling conscientious collections as a response to the COVID-19 pandemic and all of the new shelter and home orders. And we've gotten a lot of questions from our clients, so we thought it would be best to jump on a webinar and address a lot of these issues. Hopefully you'll find this information helpful. This is still a fluid situation. Things change daily with respect to the response from the federal, state, and local governments, the different rules and ordinances that are being issued. So take into consideration what we tell you today may not be 100% accurate, depending on when you view this webinar, or may not be accurate by the time we finish this webinar. So we want to talk about a lot of the financial issues that have come up, because that's what we've gotten a lot of calls about. But we've also gotten a lot of calls about other related issues or issues related to COVID-19, not concerning the financial aspect. So we thought the way we would do this today is we would talk about the non-financial issues first, kind of go through and talk about some of the issues, and hopefully we'll be able to answer a lot of your questions, and then we'll go into the financial aspects. What we would like to do is we want to encourage you to ask questions. We've got everybody muted because it would be a lot of people talking over each other. So the way we're going to try and do this is there's a chat feature within Zoom. You should see it somewhere on your display. If you could pose all your questions using the chat feature, when we get to the end, we'll go through all the chat questions or chat feature questions, and we'll try to answer them to the best of our ability. Keep in mind, this is only our second time doing a webinar, so there may be some technology glitches, hopefully not, but if there are, we apologize in advance, and hopefully you'll find this information helpful.
All right, so let's get started. First and foremost, let's talk about what an association's role is and how we should stick to that role during this crisis. Of course, it's your obligation to maintain common areas and common elements, enforce the restrictions and the rules, and to maintain the property values of your community. But of course, it's not your job to maintain the health, safety, and welfare of your residents. And so as long as we keep those concepts at the forefront and in mind, I think that'll really frame the guidance that we're providing and the actions that you'll take on behalf of your associations. It's also important during this time to be a conduit of information. People will look to the association at times for guidance and information that you can provide. Certainly be a conduit of information, provide the local, state, and even federal guidance, but don't create information, and certainly don't provide information unless it's from a reputable and valid source. Do you have anything to add about that, Greg?
Yeah, I think Adam's point is really a good one, which is you're not a governmental agency, you're not a healthcare agency, you're not a police agency, you're a homeowners association. And so even though you are going to be somewhat in the fray of responding to the COVID-19 pandemic, just keep in mind, you're not there to protect their health. And so if somebody says, hey, you've got to do this and this and this to protect the health of the residents, that's not exactly correct. You should always direct anybody who's concerned about somebody who's got COVID-19 or healthcare concerns, direct them to the appropriate authorities. Let them deal with that, because they have the powers to effectively respond to that. The association typically does not.
Along that same line, it is your responsibility to maintain and clean, of course, the common areas. And some of the questions we get about common areas are, can an association close certain common areas now because of the epidemic? And then, of course, if we can, should we? In most instances, it's going to be fairly clear that yes, of course, you can close the swimming pool, certain common areas that would necessarily involve groups of 10 or more people. It makes a lot of sense to go ahead and close those common areas, but There are some other issues, especially with high-rise condominiums, like shared lobbies, shared entrances. How are people going to get to and from their homes if the common areas are closed? And so this will be something you'll take on a case-by-case basis. You want to be smart about it. You want to have your staff cleaning the common areas as much as possible and keeping these areas sanitized. But at the same time, let's all just think about these issues and be smart and make sure that you're doing what's responsible on behalf of yourselves and your residents.
And, you know, we represent associations all across the state, a lot of which are currently subject to local shelter-in-place orders that limit the number of people that can gather in one place. So there may be, not only do you have the authority to close your common area, common element amenities, but you may be required to in certain instances, depending on where your association is located. So keep that in mind as well. We've gotten calls from some boards where homeowners have threatened to sue the association for closing the common areas. How dare you close the swimming pool or the gym? I think it's pretty well established, especially for condominiums, that the association has the authority to regulate use of the common elements. And I think that's going to be the same thing for a subdivision association. So we do think you have the authority, whether you should or not. You need to look at what's the situation of your community. Is it something that can be used where people aren't going to be gathered in one confined space? For instance, if it's a subdivision development and it's a big open park and people just want to be able to walk their dog, I think that's probably fine. But if it's a condensed room like a gym within a high-rise condominium, you should probably consider closing it. Okay. So one of the next issues we've been dealing with are meetings. Lots of associations that need to conduct board meetings and or membership meetings, especially annual meetings. For annual meetings, let's start there. You're probably well advised at this point to postpone those meetings and reschedule them. You can do electronic or telephonic meetings as long as every owner can hear and be heard by every other owner. And we know of a few association managers that have successfully done that. But that's typically going to be in your communities where there's not a significant number of owners. In most cases, you probably should just go ahead and reschedule it to a new date sometime between 30 to 60 days out. We've gotten the question though, well, what if you have board member positions that are expiring and you don't have a provision in your bylaws that authorizes a board member to continue to serve past their term of office if the meeting gets extended. I'll just tell you, typically, if you've still got enough board members that would constitute a quorum, you can always operate without every board position filled. But also, I would tell you, we're in an unprecedented worldwide pandemic, and the United States has declared a national disaster. These are unprecedented times. I would tell you, talk to your lawyers, whoever lawyer you're working with. But in my opinion, I just can't imagine any judge ever undoing something simply because y'all continue to operate the association when you couldn't conduct an annual meeting. And the other thing is these shelter-in-place rules that limit the number of people that can gather in one place are going to prevent you from getting a quorum if you try to call an annual meeting. And if you don't have shelter-in-place rules, chances are owners aren't going to show up anyway for those same reasons. So I think you're safe to continue to operate, but if you have concerns, talk to the lawyer who's working with you. Maybe consider amending your bylaws to allow board members to continue to serve until you can call your annual meeting. I did that for an association just yesterday.
And these are all good strategies. Be sure to contact your attorney if these won't work for you. If you don't have a quorum of board members because everyone's term is expired, there are solutions. We can do voting by mail. We can come up with some creative solutions. And again, board meetings don't necessarily have to be held every single month. And remember, this is an emergent condition, and the property code does allow for actions to be taken outside of a regularly scheduled board meeting when you have an emergent condition. I can't imagine that this would fall outside of that exception. and contact your lawyer, and they can certainly help you through this issue and get the approvals that you need so that you can continue to operate and continue to pay your bills and continue to provide your members with the services that you're obligated to provide.
And also, boards can continue to still meet by electronic or telephonic means as long as all the directors can hear and be heard by each other. There are a couple of limitations for condominium boards as to what they can vote on. For subdivision associations, there's some additional procedures you need to make sure that all of the homeowners can also at least attend and observe the meetings using the same electronic or telephonic communication tools, and that you put the instructions for accessing that in your meeting notices. But you still can meet. So if you've got questions about the procedures or options available for your board or your association, reach out to whatever law firm or attorney is assisting y'all, because they should be able to assist you in being able to continue to conduct board meetings. So what's the next issue that we keep getting calls about?
Well, we keep getting calls about regulating or restricting guests, especially in condominium associations. Of course, it's the can you question and should you. This is going to be a tricky one. In a lot of instances, guests may be significant others. Guests could be providing care. Guests could be delivering groceries. And so it's very important that we think about limiting guests in a very conscientious way so as not to cut people off from needed services. I think you mentioned something the other day, Greg, about helping your elderly residents get deliveries of groceries and those types of things, and setting up policies and procedures that would allow for a little extra assistance for those that shouldn't and can't go out to get their own supplies.
Yeah, so a couple of things there. If you are going to limit guests being able to come into your condominium, and this is where that really comes up, make sure you have ways to facilitate residents' ability to still function. Grocery delivery, meal delivery, packages posted or postal items. Make sure you have people who can receive those and either deliver to them at their units. They might also need to have stuff sent out. So you might have implement a procedure where people put mail outside of their door, or maybe they need to be able to deliver trash or deposit trash into a receptacle. Maybe you have somebody on the management staff go around and collect the trash from outside of the unit doors, just to facilitate people's ability to self-quarantine, and also the ability to limit the amount of people coming in and out of the building. If you're off, you might also consider having, if it's a condominium, have maintenance staff really thoroughly clean all of the common element areas where people are coming in and out, and especially surfaces that are commonly touched, like counters, doorknobs, elevator buttons, and do that on a routine and regular basis. So one of the questions we've gotten, can you require residents to self-quarantine? Can you say you're not allowed to come to the hallways, or you're only allowed to come out of your units for essential tasks? And the answer is no. Again, if you know, people can do it on a voluntary basis, but you cannot really restrict unit owners and tenants coming in and out of their units. You just can't. But if somebody wants to self-quarantine, again, I think it's important that you implement strategies to assist them by helping them, you know, not have to leave their unit. Again, that goes back to delivering either groceries, meals, anything that's brought to them at the building to their unit, and anything they need to leave their unit, whether it's postal items or trash, you know, picking those up. But you cannot force somebody to self-quarantine.
And that brings up another issue. One of the questions that we get from some of our associations who are trying to be as conscientious as they can during this epidemic is what happens if a resident tests positive? The way that I've had the question posed to me is, well, what if there's a confirmed case in our community? And this is especially relevant for condominiums. Now, if a resident tests positive and lets you know about that, it's important that you don't violate their privacy. At the same time, you want to balance their need for privacy with everyone else's need to stay safe and be healthy. And so how can we do that? The first way to do that is to simply ask the resident, if they're reporting to you that they have tested positive, if you can share that information. It may not be important to share information that Jim down in Unit 101A has tested positive. Instead, I would simply ask, are we permitted to let the other residents know that somebody within our community has tested positive? If they say yes, you can continue to ask some questions that narrow it down. Can we let the community know that it's somebody on your floor? Can we let somebody know that it's, can we let the community know it's someone in your unit? And finally, are we permitted to let people know it's you? And then simply, if you're going to disclose the information, don't disclose more than you've been given permission to disclose. We think that this is the best way to balance the needs of privacy with the needs of the community to stay informed and to protect themselves.
And keep in mind a couple of things. One, the association is not under any obligation to disclose that information. In fact, may be prohibited from doing so. If they're asking for an accommodation or a reasonable accommodation because they've got COVID-19 and they're self-quarantining and they're saying, I can't do this or I can't comply with this rule because I've got COVID-19, when it's in the context of a reasonable accommodation under the Fair Housing Act, you're by statute prohibited from disclosing that information to anybody else. Also, don't be bashful or shy about asking the owner if you can disclose it. The reality is they actually may want you to. If they are trying to self-quarantine and they don't want to spread it, they may feel, they may want everybody to know so that they're not coming to their door. Or if they have to come out and walk down the hallway, that people know not to come up and talk to them. So you might find that some of the owners really do want you to disclose that information. But again, I would check with the owner first before doing so.
And again, there's only a few thousand confirmed cases in Texas at this point, so there's a very good chance you won't even have to deal with this issue.
At least not this week. So the next issue is, should you continue business as usual when it comes to covenant enforcement or rules enforcement? I think you've got to take a common sense approach to this. We've got, again, an unprecedented scenario going on here. We're seeing, businesses shut down. We're seeing the inability to travel if you're in an area that's got a shelter-in-place order. They're having to do things that they wouldn't normally do. They might have to have certain people come to their unit or their home. They might even park certain vehicles in their driveway. It's really something that they can't or may not be able to work around. So I would say use common sense. If it's something that affects, property or somebody's health or something that you really can't ignore, then by all means, go ahead and enforce it. But if it's something that you think is a temporary issue, you think it's related to COVID-19 or the shelter-in-place ordinances, maybe take a little bit more relaxed approach to it, is what I would say. Also, we don't know yet. I think, though, if you look at the definitions of a disability under the Fair Housing Act, COVID-19 may qualify because it does affect one of life's major activities, especially if you're having respiratory issues. And if somebody says, I need a variance or I need you to not enforce it, some rule because I'm experiencing health care issues with COVID-19, that may be considered a reasonable accommodation and you probably should grant it. So just use common sense, but at the end of the day, if you've got concerns or questions or you're just not sure, always reach out to the attorney for your association. I think that's it for our non-financial topics.
That's correct. That brings us to the main topic of today's conversation, which is association, financial stability, as well as the conscientious collections. Conscientious collections. I should probably go ahead and say the name of our webinar correctly. And really, first and foremost, the association has to continue to maintain its finances. Your association exists to undertake certain obligations. Those obligations necessarily cost money, and it is highly unlikely that the vendors that provide those services to your association and the various bills that the association owes are going to relax their requirements that you pay them every month on time. And so because of that, it's important that you maintain your assessment base?
And we've been asked a couple of times now, and I've actually seen some emails where boards or management companies have been recommending that associations, in response to the COVID-19 and all of the economic ramifications of what's occurring right now, go ahead and just abate assessments for 30 to 60 to 90 days. And Adam and I both think that that's ill-advised for a couple of reasons. One, not every owner is equally affected by COVID-19. There could be a lot of owners who are completely unaffected by it. They still have their jobs, they still have their income. They could be retired and still getting income. So we don't know how many owners are actually being affected. We also know that the federal government is starting to send out checks to owners, or some of your owners potentially, which they could then use to pay their bills. So I think it's still early on. This is not likely to end in the next month or two, and the full ramification and fallout, economically speaking, as a result of COVID-19, we can't even anticipate at this point. You know, if you've read the news, we've read the news, but you look at the data, unprecedented number of jobless claims at any one given time. We're seeing these extension of the federal and state stay-in-place orders, which are going to close a lot of businesses now through the end of May. It's difficult to predict what's going to happen, and the association needs to ensure that it's in a financial position to continue to be able to repair, replace, maintain, ensure their common areas and common elements, and pay essential vendors like management companies and others. And so I think it's a little too premature to start giving abatements on assessments to owners at this point. That's just something that we have to continue to monitor. Now, if the association does not have enough money or is unable to pay all of its bills at this point, you certainly want to talk to your attorney. There may be certain vendors and services that the association is under contract for that they either don't need now or may not need for some time that maybe you can get out of. A lot of contracts have what's called a force majeure clause, which is Latin for act of God. And the pandemic and national disasters, depending on what your contracts say, may give you the ability to opt out of a contract or abate any obligations you have under a contract until it's feasible to do so. So that's an issue that may come up for some of your associations where you're stuck in a contract, but you're not able to accept the services or don't need the services. One example is pools may not be open for some time, and so you may be under a contract with a lifeguard service company, and you may not want to pay for lifeguards that can't work for a pool that you can't open. So that's one thing to consider. So what should you be doing right now when it comes to the payment of assessments? We're telling you don't do abatements, but what should you do? Well, I think you have to be mindful, again, of the economic situation, again, unprecedented. We aren't sure what the full effect of this is going to be, and we assume that there's going to be a lot of owners that are affected by it. And it could be through a number of ways. It could be owners that are affected because they've lost employment. It could be owners who have been leasing out their homes to tenants, and the tenants have lost their employment and are not paying. Or you've got the different cities trying to enforce grace periods for tenants against landlords, which may prevent landlords from being able to evict their tenants, which means they've got no income coming in. So there may be some domino effects here that affect owners. So what I would tell you is don't approach it on a blanket basis where you're doing wholesale abatements. Do it on a homeowner by homeowner as needed basis. We're talking about this as a conscientious collections approach, but to be honest with you, what we're going to talk about today is what we talk about all the time when it comes to collections. We're a big believer at our firm that you should always engage in conscientious collections. So what does that mean? Well, what that means, at least to us, is being mindful of not only the ability of owners to pay and their ability not to pay, but their ability to get caught up in the future. In my experience, typically speaking, when it comes to owners who aren't paying their assessments, they fall into one of three categories. The first category is what I call the oops, I forgot group. They have the money, they just simply forgot. You send them one notice and they say, oops, I forgot, and immediately write you a check. The second group, I tend to refer to them as the civil disobedience group. They've got the money, they're just not paying it as a form of protest. It's typically because they're really mad at the manager or the board or the neighbor, or they don't think they're getting sufficient amount of services or benefits for the amount they're paying. The irrespective, they are also easy to collect from because they're angry, not stupid, and they'll never allow their home to be foreclosed over a protest. It just may take a little bit of effort, but they'll always pay. The third group is the group that I call the hardship group. And the characteristic for them is something has happened in their life, an unanticipated event that has rendered them now unable to pay their bills as they come due. The big three are typically going to be loss of employment, divorce, and healthcare issues. Well, right now we've got two of those. A lot of people suffering either from healthcare issues or maybe bills or loss of employment. And so I can foresee a lot of people having that hardship. So what we've always said is when it comes to people that fall into the hardship group, the most important thing you can do is reach out to them as early on in the process and find out, how come you're unable to pay your assessments? Why are you not paying your assessments? If it's the oops, I forgot group, they're going to write you a check right away. If it's the civil disobedience group, just know you have to continue to do your collection activity because that's what's going to be required to get them to eventually pay. But when it comes to the hardship group, you need to work with those folks and get them on a payment plan as early on in the process as possible. When I think about the way some associations approach it is they'll say, well, let's just wait until it either gets a number of years behind or up to a certain amount in debt before we really start taking this serious or we really start engaging in collection activity. And I think that's always the wrong approach. And the reason for that is debt is kind of like a hole. And when you allow somebody to keep digging that hole, they're going to keep digging that hole, and you may allow them to dig it deep enough that they can't get out of it. And so what we want you to do, what we always recommend, is give them a smaller shovel. Get them on a payment plan so that maybe they're not paying all of it, but at least when they get to the point where they have the ability to pay, the amount of debt or the depth of that hole is not as deep as it would have been. And now they're able to manage to dig themselves out of the hole. So what we want to do is prevent people from getting so far in debt that they can't pay anything off. I call this the point of insurmountability. And you can always tell when a homeowner's reached the point of insurmountability, it's because they won't respond to you. You can offer them a $5 payment plan every month and they'll never respond. And it's because they've lost the ability to believe that they're ever going to be able to get out of debt.
And I think it's important to keep 3 or 4 things in mind. The first of which is every step in the legal collection process, at least with Cagle Pugh, is an attempt to get the owner's attention. We want the owner to contact us. Everything that our collection professionals do is to set up an alternative payment schedule with these folks. It's very, very rare that by the time it's made it to our office, after sending one letter, the homeowner calls and says, no problem, I'll write you a check. Sure, it happens, but almost all the time we are filing lawsuits or liens in order to get the attention of the owner so that they'll call us and set up a payment plan. And that's still what we're doing during this epidemic, is simply trying to reach reasonable payment plans. What reasonable means now may have changed a little bit, but that's part of the process as well.
One of the things that you can do, though, and what we might encourage you to do is, given the current unprecedented economic situation that's likely to be ongoing, is we recommend maybe waiving late fees or interest. So that's one thing that you could do. Also, when it comes to those payment plans, we highly recommend that you consider extending the terms of it. So if you're normally only allowing somebody to pay over a 6-month period, maybe consider extending that out to 12 months or to a year. Help ease that financial burden. That's one thing you can do in response to any financial hardships people might be suffering as a result of COVID-19. I think you were going to add something.
I was, but I think that was a perfect time for that comment. The other thing that I was going to mention is that if you have owners who are already at the attorney's office, whether it's ours or anyone else, it's not because of the epidemic. There are owners that have been delinquent for multiple years, and that's how they're already in our offices. And so at this point, to simply discontinue the collections with respect to owners that have been delinquent for an extended period of time just doesn't make sense. It's a remedy for the wrong problem. So allow your collection professionals to continue working, allow them to continue working on payment plans, and allow them to continue getting matters into the queue when litigation resumes again. Remember, most courthouses are closed for the foreseeable future, at least until the end of April, some through the middle of May. I know I have multiple cases that aren't collections with dollar values in far in excess of what you would see in a HOA collection case, and we can't get hearings until May and in some cases June. But it will be important to get your motions for default judgment and motions for summary judgment and other issues in the queue. What we're hearing from many of these courthouses is that judges will, when they can come back to work and have the assistance of their staff, they will begin to start taking these up on a submission basis. Who knows how long that will take? And they're going to take those up in a first come, first served fashion is what I'm hearing. And so we should continue to get our actions in the hopper. There may be a 3, 4, 6 month wait to have matters heard when the epidemic subsides. And so we should continue to work these cases so that we have the best opportunity to resolve these matters for your association without having to get through this large queue before we can be heard.
And almost all counties have shut down foreclosure sales. Those are not going to be happening at least through April and most likely through May. So really, for the most part, we're not going to be doing any actual foreclosure sales of any properties. But what we do want to do is make sure we're continuing to preserve the ability of the association to collect its assessments if and when the pandemic and all of the other shelter-in-place ordinances and closing of courthouses ends. But that being said, if you've got a collection matter that's approaching the 4-year statute of limitations, it's really important that that you work with your attorneys to make sure that at least you get the judicial foreclosure lawsuit filed so that you can stop the statute of limitations. And one other thing you can do, we would really encourage you to work with your attorneys to pre-approve these extended payment plans. Because typically what happens is when we offer payment plans to owners, we go off of what the association has said that we're permitted to do without further board approval. If a owner says, well, I need a lot longer to be able to feed myself and do other things, we then have to communicate with the board to get those extended terms approved and communicate back to the owner. Well, all of that activity by the attorney or the paralegal means additional attorney's fees added to their account. If we want to keep that hole as shallow as possible, we want to reduce the amount of attorney's fees. And so one way that you could do that is get with your attorneys or have your boards pre-approve the attorneys to enter into payment plans up to, and maybe it's 18 months or 20 months or 24 months as necessary to get owners on a payment plan. And so by doing that in advance, you can reduce the amount of attorney's fees and the amount that the owner may owe who's trying to figure out a way to get everything paid off.
And that's good advice all the time. If you have an open dialogue with your attorney, if you have pre-approved payment plans in advance, this saves some steps in the process. It gets the association their money faster, and it allows our folks to enter into reasonable payment plans with owners as expeditiously as possible.
So we're now at the Q&A part. I'm looking at the chat box here. I don't see any questions yet. So if you've been saving them up.
I think the screen we have may not have all the questions. Marla,
Are you seeing questions, Marlo?
if you're able to read to us some of the questions, that might make this process a little bit easier.
In Dallas, it was on local news that there have been a positive test in a high-rise apartment building. That was just letting y'all know. And then, should we be doing drive-through inspections in single-family communities? Would this fall under us being out because it's essential?
That's a really good question, and it's going to depend on how they've defined essential activity wherever you're located. So I would say talk to the lawyer for your association so that they can look at the shelter-in-place order. They're not all identical, though they use roughly the same language. But I do think it is an essential activity, I think, under the ones that I've looked at. But you might consider relaxing that a little bit. But if you need to do it, I would say, I think it would be considered an essential activity.
And they're in Dallas County.
In Dallas County, the Dallas County shelter-in-place order looks very similar to many of the orders around the state. Essential businesses, I do believe, include property management. And the way that I've analyzed that for some of my clients is that homeowners associations obtain and provide to, and condo associations obtain and provide to their owners what would be considered essential services. And so because the association is a nonprofit association generally run by volunteers, the only way that it obtains those services is through its management company. So the management of the property, providing those services, paying the bills, the financial management, those are all essential services. And so I do believe you can continue to operate. I would also argue that if you're in your own vehicle, you are secluded from the rest of the folks that you work with, and that satisfies most of the shelter-in-place orders that I've seen around the state. So that person, at least in their vehicle, is following all the recommendations and certainly staying the proper distance away from everyone else. Do we have any other questions, Mara?
What is your recommendation for violations, fines coming from monthly inspections?
Again, I think you might look at them to see if it's something that is new and maybe related to the shelter in place or anything having to do with the current pandemic. I would take a little bit more of a relaxed approach to that. But again, I think you have to look at it on a case-by-case basis. So you can still do it. I see another question that just came in. Do you want to read that one or do you want me to?
If you have it.
With courthouses being closed, what do you recommend regarding amending bylaws to allow expired board positions to continue during times of emergency until the annual meeting/election can be held for terms that end in May 2020? The courthouses are closed for all the emergency hearings, but the county offices are open for filing documents in the public records, which is where you would file it. In addition, most law firms, including us, we have the ability to electronically record it. So if the association adopts a bylaw amendment and it's signed by an officer of the association, we can electronically record those without even going to the courthouse and without having to hand anything to anybody. So that's not going to be an issue.
And I think it's a great idea. If you can amend your bylaws in such a way as to continue to allow the currently serving board members to operate on behalf of the association, I think it's a great idea, and we highly encourage it.
Okay, that's all the questions. Oh, here's one. Do we need to delay or postpone maintenance on the buildings in our condo complex because of the current situation? Anything that's elective and not necessary, you can. It's our understanding that plumbers, electricians that would come out and service anything that you needed service in an emergency, those are essential businesses. Construction is kind of considered an essential business as well. But you might consider how many people do you want coming into your condominium building when thinking about that. But you can still have service providers come out to work on any of your mechanical systems, plumbing systems, electrical systems, if needed. But if it's purely elected, maybe it's just a remodeling job, you might consider putting it off for a couple of reasons. You may have supply issues. Your contractor may have labor issues. There's a number of unforeseen things that could occur if it's a big project. So you just have to look at it on a case-by-case basis, maybe talk to the contractor and look at it from that perspective. All right. Are there any suggestions for closing amenities like playground equipment, basketball courts, et cetera, that cannot be physically closed? You could put up a notice, like just a piece of paper that says, you know, that these are closed. The reality is you really can't close them. It probably wouldn't make sense to go out and try to clean them either. But again, you're not a governmental agency. You're not there to protect people from themselves. They're aware of the situation. They're aware that they're not supposed to be gathering and they shouldn't be going to parks. And if they do, that's not your responsibility. And if you can't physically close it, then I probably wouldn't do much other than say, you know, we recommend, you know, that you not go there. And there may be shelter-in-place orders that, you know, instruct people not to. Okay. If a HOA has a homeowner that has not paid dues in over 10 years and the board voted to proceed with foreclosure, is that something that should wait until this is over? The answer is no. I would go ahead and file a judicial foreclosure lawsuit just to stop the statute of limitations. You're not going to be able to get a trial or a foreclosure sale done over the next 60 days. But at the very least, you need to get a judicial foreclosure lawsuit filed to stop the statute of limitations because it's a 4-year statute of limitations and you may not be able to collect anything over 4 years.
Sure. Let's see. Any suggestions, cautions to doing a Facebook Live for the monthly HOA meeting? We've never done this before.
Well, the only requirement is that everybody be able to hear and be heard by everybody else. And if you're going to vote on anything, that you're able to identify everybody and record their votes. Those are the requirements under the nonprofit corporation law. There are no additional requirements for membership meetings under the Uniform Condominium Act or Chapter 209. So as long as everybody can hear and be heard, and as long as you're able to identify for voting purposes all of the owners. Now, keep in mind also with Chapter 209, there are ballot requirements. So all ballots except for electronic ballots have to be in writing and signed unless you have adopted secret ballot rules. So you might want to coordinate with your attorney about how you're going to conduct the votes with ballots. But as far as the technology goes, you can absolutely have a meeting. The only requirement is everybody being able to hear and be heard by everybody else.
And I think this is referring probably to board meetings, since it's a monthly meeting it's being referred to. So again, just talk with your attorney, but this should probably be something that would be feasible. You just need to make sure that the link to how to access it, even for non-Facebook members, is available. If you have to require somebody to register for Facebook, we may need to look into how you can feasibly do this, but there's got to be a way to make it work. Okay, the next question is back to single-family drive-through inspection. We do inspections in a company car, and we always do it with 2 people. Would that violate shelter in place? This is in Ellis and Dallas County. Well, that's an interesting question. I think if you've got 2 people in the same car that don't already live in the same house, you might be violating those shelter-in-place rules. It seems to me like something that could be accomplished by one person driving. I understand that the reason for doing this is multifold. You've got 2 sets of eyes instead of 1. You've got one person to drive and one person to ride. That way, the driver can focus on what they're doing. But it seems like in this situation that we should probably be doing single-family drive-through inspections with one person. They may just have to stop more often. take their hands off the wheel, put the car in park, and make their notes or take their pictures. I do believe that at least in Dallas County, this would probably violate the shelter-in-place order. I don't recall if I've looked at Ellis County yet.
I don't remember if they deal with people in a private vehicle. Usually it's a public place. So let me just say, I'm not sure. We have to go back and look at that for that specific of an issue. Also, if you're with a management company, talk to the people at your management company about what they're doing. Your management company might have certain policies, but in a private vehicle, I'm not sure that the gathering, because usually it's people gathering in a public place that's really the issue. Talk to the attorney. We've not looked at those orders specific to people in a vehicle, so I want to be careful.
No, that's correct. I'm doing this from memory, and I'm thinking about only the social distancing and the requirement that folks that are working at essential businesses be separated either in separate offices or cubicles or by distance.
And so you can see Adam and I are not 6 feet apart at this point, so we've taken a little bit of a risk here, but I think it's fine. So, use your head. I mean, at the end of the day, we want everybody to be safe. The whole point of this webinar was to, make sure that you guys kind of know what you're required to do, what you're not required to do, what you really should be doing with regard to the finances. We originally came up with the idea that when we started seeing emails about abating all assessments, and we thought, oh my God, associations really should not be doing that. They've got to ensure they have the financial ability to carry out their functions and duties. Homeowners, not all homeowners are affected the same way. And so we thought, well, let's throw together a quick webinar. We've never done a webinar before. Hopefully this has been a positive experience for everybody. Looks like we got one more question. We'll get to this one more question, but thank you guys for your patience, and hopefully this has been a good experience.
What do you recommend for electronic telephone board meetings where homeowners exceed their 3-minute maximum speaking time? You may not be able to silence them, so what do you do?
Well, I don't know what technology you're using, but a lot of them allow the host to be able to put people on mute. For instance, when we were setting this up, I made everybody muted, and we gave everybody, or we removed the ability of anybody to unmute themselves. So it can be done. We were using Zoom. There may be other software applications that allow you to do that as well. So you've got to look at it.
You skipped over one question.
Oh, we skipped one.
Sorry. Police departments are closed in SA to the public until April 19th. Due to that, I am unable to obtain police reports regarding association damage. We then are unable to submit the responsible party's insurance. Any suggestions?
You're just going to have to wait. If you can't get the investigation reports from the police department, then there's not much else you can do.
Yeah, and I would just recommend contacting the adjuster or the claims manager, whoever you're dealing with, and explain the situation. They may have an alternative, and they may be able to waive the requirement of a police report, give you a sworn statement or something like that you can use. Well, thank you all so much for attending. We enjoyed it. We're glad that we can be of service. And if anybody has any other questions, certainly feel free to email or call us anytime.